The next element we're going to look at is contractual capacity. And this is the mental capacity to enter into a binding contract. And there's a couple of different ways that are important for businesses to be mindful of, where a person who really does have mental capacity doesn't have the legal capacity to enter into a contractual relationship. So this may be a person who is determined by a court to be mentally incompetent. That would be someone, we call it non-compos mentis in Texas, but a person determined by a court not to be mentally competent. And there's other situations as well. Minors. And that is you until you are the age of majority, which in Texas is 18. So when you reach the age of majority, you have contractual capacity. There are other ways. If you're an emancipated minor, you might as well. Emancipation occurs when a child's parent or legal guardian relinquishes the legal right to exercise control of the child, or where the child presents a case in court. He or she no longer wants to be a child, wants to be emancipated. The general rule is a minor can enter into any contract that an adult can, except contracts prohibited by law for minors. A contract entered into by a minor is voidable. That means the minor, at the minor's whim, can turn an otherwise enforceable contract into a void contract. A minor, a 16-year-old with $100,000 in cash, can go buy a Porsche. That same minor can drive that Porsche for 2 weeks and then total it, and then walk away from it, go back to the dealership and say, I'd like to exercise my right as a minor to make my voidable contract void. Please give me my money back. Sounds goofy, doesn't it? Well, that's the law. A minor can disaffirm a contract. Now, there are some exceptions, but disaffirmance is the legal avoidance or setting aside of a contractual obligation. You do have to express your intent, and you can do that through words or conduct, but disaffirmance is allowable. And the minor does have to disaffirm the entire contract, not just a portion of it. Be mindful, only the minor can disaffirm. That is, if you are a car dealer, or let's just say you're a car owner, and you're selling your car for $10,000. You're an adult, and you sell it to a 16-year-old. I wouldn't. Because that 16-year-old can disaffirm that contract. And if you have a 16-year-old who gets in a car accident, he can come back to you and disaffirm the contract for the car, and then you have to give him his money back, and you get your car back, or whatever is left of it. There are some states that require the minor to bring back, or if they're going to disaffirm the contract for a car, they have to bring back the car and make the other person essentially whole, but that's a minority of jurisdictions. A reasonable time for a minor is until they turn 18, for sure, and then plus a reasonable time after that. So if you are making car payments on a car as a minor, the day you turn 18, you still have some time. If you have a whole nother month before your next payment, you could probably wait until almost the end of the month and then disaffirm and not have to make your payment and get your money back. Not a good idea to do contracts to form them with minors. We strongly encourage you not to. There are some obligations. All states do permit minors to disaffirm, but some make the minor return the goods and put the person who sold the goods back into a place they were before. And then sometimes it allows, while you can disaffirm the contract, you can sue it for tort damages if there was a misrepresentation of age or something like that. There's this additional duty of restitution in some states. Minors can disaffirm contracts even when they've misrepresented their age, but you can probably sue the youngling for fraud, and because it doesn't matter how old you are, you can be responsible for fraud in most states. So at 16, you could be sued for fraud if you made a misrepresentation of your age. There are some exceptions, although these are not really exceptions. A minor who enters into a contract for necessaries, food, clothing, may disaffirm, but you remain liable for the reasonable value of the goods. So it's sort of an exception. They still get to disaffirm, but they do have to, or they do remain liable for the reasonable value of the goods. Why is that? Because I'm telling you not to make contracts with kids, but some kids have to because they need to eat, they need to have clothes, they need shelter. So the law allows for people who want to, in good faith, provide these necessaries to minors. There's this extra layer of protection for them. If you're 16 and you form a contract and then you turn 18, you can also ratify the contract, and you can change the voidable contract into a valid contract. It's called ratification. You can have express ratification when you write to the car dealer and say, I hereby ratify this contract as a person who has reached the age of majority. Or you can keep making payments for 6 months, and a court will likely see that you continue to make payments after you're 18, that you were ratifying by your actions. And then courts have provided a safety buffer zone here. If a minor fails to disaffirm it within a reasonable amount of time, the court itself determines whether the conduct constitutes this ratification or if it constitutes disaffirmance. Parents are not liable for contracts made by minor children. However, most businesses require co-signatures. Or you have a 16-year-old who's using mom's credit card to buy a dress. Well, guess what? That's mom's credit card, and you can have a younger than 18 agent, and it will bind the principal. So many times it's not really technically the child buying something, is really the parents, and the child is merely the agent of the parents. Another way you can lose contractual capacity is by becoming very intoxicated. You have to be very intoxicated, but if you are so intoxicated that you don't have normal capacity to act or think, you can probably only form a voidable contract. And this is very hard to prove, and it doesn't mean you've had 2 sips of wine or maybe even a bottle of wine. You have to be what I would consider really drunk, not just legally intoxicated, in order to do that. The agreement may be voidable if you are really, really drunk. If the person, even an intoxicated person, did understand the legal consequences, it's valid despite intoxication. And courts will look at objective indication of the condition the person was in. Disaffirmance will have to take place as soon as you're sober, so a reasonable amount of time after becoming sober. So you're not talking about months. You might be talking about a day or hours. Contracts for necessaries are voidable, but the intoxicated person is liable in quasi-contract for the reasonable value of the consideration received. So this is like a minor's disaffirmance. It's a little different, but it's like a minor's disaffirmance. You can still disaffirm, but you're responsible for the value. And an intoxicated person maybe is a fantastic negotiator when that person is drunk as a skunk, and you certainly can ratify the contract you formed when you were not sober. Mental incompetence, it depends. It could be a valid contract, a void or voidable contract. If a court has adjudicated you as mentally incompetent, the only kind of contract you can form is no contract. It's void. And then you will have a guardian of the person or of the estate, or both. A party who is not determined to be mentally competent by a court may avoid a contract if at the time of contracting the person did not know he was entering into a contract or lacked the mental capacity to understand consequences, the nature of purpose. And only the incompetent party has the option of disaffirming this kind of voidable contract. And then, just like you might understand or expect a contract entered into by a person who is mentally ill but not adjudicated incompetent may be valid if at the time the person signed the contract, sort of a lucid interval, so it's possible to form a valid contract. Now we're going to move to legality, and this is probably the easiest to understand. If a contract to do something is covered under federal or state law, and that's illegal, it's void from the beginning. We call it void ab initio. It's void and unenforceable. You cannot have a contract, for instance, to hire someone to assassinate another person. It's void from the outset. But what would you do about a contract for the sale of marijuana in a state where it was legal to have recreational marijuana? So it's not illegal at the state level, but it's still a federal crime. It's interesting. How would you enforce contracts that way? So any contract that is contrary to law or statute is void ab initio, like contracts to commit crimes. Usury is illegal, therefore it is void ab initio. In most contracts with loan or usury, or rather interest provisions, have something in the contract that says if any part of this contract is determined at any point to be illegal, then that part will be essentially cut out. Or there are things where you would say, we want to charge 25% or the maximum amount allowed at law. So there's ways to get around this, but if you don't write those kinds of things into your contract and it's determined that any part of your contract is illegal, you might lose the entire deal. Most gambling contracts are illegal. There's a case, maybe you're interested in it, where someone had a credit card with a forum selection clause. I believe it was Connecticut. And he used his card to withdraw cash from an ATM inside of a gambling institution. He was inside the building. He got money out of cash advance, and he used it and lost it. And the bank came after him and sued him. And he responded, "Oh, I'm sorry, this was for an illegal purpose, therefore it was illegal. Therefore, I don't owe you any money." And he won. Although don't try that. Most contracts have been amended to cover that these days. This is a trick question on the exam, so I guess it's not because I'm telling you. It's just remember this. All sorts of licenses out there. As an attorney, I have a law license. But there's also a commercial fishing license. And if you have a contract with me to perform legal services, and then you come to find out that I really don't have a license, no contract, you owe me nothing. If, however, I have told you I have a commercial fishing license, and I take you out and we go fishing, you have a good time, and then you find out I really didn't have one of those licenses, you might still owe me. Because there are different purposes for licenses. Some licenses issued by the state of Texas are for revenue purposes primarily, and then others are to ensure competency, like physicians or dentists or nurses or attorneys. So if it's an unlicensed person, if it's the kind of license that's there to protect people, probably void. If it's the kind of license to generate revenue, probably valid. Other contracts that are illegal but not really illegal are public policy violations. So if you have an employment or let's say recruiting contract and you want to hire people and you tell them in the contract you're not allowed to hire anyone who is a person of color or women, you can only hire white males, that's contrary to public policy. Or contracts in restraint of trade. Some covenants not to compete are going to be considered too restrictive and will not be enforceable. So you will probably at some point in your life sign one of these kinds of contracts, especially if you're at a high level and you're going to have access to customer lists and other things. You might have a covenant not to compete in your employment contract. Non-compete agreements are legal, but you have to be very reasonable in your period of time and your geographic location. And then unconscionable contracts. Bargains that are so oppressive that the courts relieve innocent parties of all or part of their duties. Procedural unconscionability is when you write something in tiny print or you use legalese in such a way the average person or the consumer couldn't even understand it, and courts will look at these for purposes of justice and fairness. An adhesion contract is one that is written exclusively by one party and presented to the other on a take it or leave it basis. When was the last time you negotiated any major term with your cell phone provider? Sometimes these kinds of adhesion contracts are okay. And you should look at it on 14-1. It's an exhibit in your textbook. This is helpful for you to figure or to sort of analyze these kinds of questions that you might come up with on a quiz or in a final exam. Exculpatory clauses may or may not be enforceable. They are enforceable when they're not against public policy. They have to be clear, not ambiguous, and they cannot shield parties from intentional conduct. I'm not responsible even if I punch you in the face on purpose. It's not going to hold up in court. And then these kinds of discriminatory contracts I told you about, those are contrary to public policy and maybe law. But those are unenforceable. Here's the effect of an illegality. An illegal contract is void. It is void, and both parties are usually considered to be in pari delicto or equally at fault. If the contract is executory, that means there's at least some part that hasn't been finished. Neither party can enforce it. If it has been executed, neither party can recover damages. In some cases, there's some exceptions. If you really had a really good reason or a justifiable ignorance of the facts, or you were actually a member of the protected class that the law was designed to protect. You're a member of the class of people that the law was designed to protect. And here's some other exceptions if you signed that illegal contract and it was fraudulent, or you were induced by fraud, by duress, or undue influence. And then what I was talking about earlier are severable contracts, and they're distinct parts. And if one part is determined to be illegal, you might still have a good contract with the rest of the parts. Exhibit 14-2, this is one that you highlight. This will be very helpful. These are the kinds of contracts that are illegal or that won't stand up, won't pass muster when it comes to a court's review. And if you prove up one of these, you see in blue or in this sort of orangish color, you will have no contract at all.